I would like to welcome everyone to today's webinar, Employment Law and Benefits Spotlight Europe. A few key items before we get started. Links to today's presentation and recording will be sent out to all registrants within 24 hours. The link to the presentation is already posted at the nair.co.com website. We encourage everyone to ask questions throughout the webinar, which will get answered later during the Q&A session. Please go to the question box in your GoToWebinar control panel to send us a question. A few learning objectives. We will be learning a few things in this webinar, namely, what are the key highlights of employment law in Europe? What are the various leave entitlements available to employees? What are the general employee benefits in Europe? How do you implement a group benefit policy for employees? I would now like to introduce our first speaker of our two speakers today. Stuart Douglas, Director, Human Capital Consulting. Stuart leads Nair & Co.'s international HR service that handles employment law, compensation and benefits, stock options, expatriate tax, and immigration-related issues for clients. Stuart successfully operated as a client services director for several years before returning to the international HR service, which he had nurtured and developed into a full-scale unit during his early years at Nair & Co. Over to you, Stuart.
Thanks, Anuja, and a warm welcome to everyone attending today's webinar. So without further delay, and mindful that we have a lot to cover, let's make a start. So if you've logged in, then you're obviously not put off by the subject matter of today's presentation, global employment law. However, foreign employment law seems to strike the fear of God into many of our clients, so much so that it can actually be a determining factor in whether they expand into a region or not. Like most fears, it's a fear of the unknown, built on an assumption that foreign laws are radically different to the US, and each country is wildly different to another. In advising clients over the years, it became clear that to remove this fear, we need to do two things. We need to identify the main differences with the US, and for each of those differences, identify the common approach taken by most countries. We can then formulate a checklist of questions which will help you map the legal position in a new country and uncover any variances from the norm. I learned many years ago that only a checklist can uncover the quirks in a local country. The local experts don't volunteer these because understandably to them they don't appear quirky. So now let's look at the key differences and start formulating our checklist, starting with what most would consider the biggest difference of all. Employment at will versus termination law. So we all appreciate that this is one of the key differences. Termination in the US is mostly employment at will, and in the rest of the world it is not. But just how different are things? The best way to present the European position on termination is to view it as a sliding scale. At one end you have employment at will, and at the polar opposite of this is the just cause termination. And between the two you have increasing levels of responsibility. If we consider a just cause termination as the worst case scenario, then it makes sense to get an understanding of what this entails, especially given the fact that most European countries follow this approach. The concept of just cause usually requires a fair reason and a fair process. If either one of them is deficient, then the termination could be deemed unfair by a court. If we start with the reason, most countries will recognize three main reasons to justify termination. 1, conduct, 2, performance, or 3, economic. However, as I've just highlighted, it is not sufficient to merely have a reason to terminate. You must also follow the right process. And from our experience, more often than not, the employer will mess up the process rather than the reason. So let's look at the processes. For a conduct termination, the employer will need to show that the individual has been taken through a disciplinary hearing and issued with a series of warnings prior to being terminated. Just how many warnings are issued will depend upon the severity of the misconduct. So instances of physical assault or fraud will generally fall within the local definition of gross misconduct and justify an immediate termination. For issues falling just short of gross misconduct, the employer will be justified in issuing one final written warning prior to terminating, whereas for misconduct of a lesser nature, such as tardiness or dress code violations, the appropriate process would be a series of warnings culminating in that final written warning before termination. For performance issues, the employer must clearly communicate the standards required and the employee's shortcomings and provide the employee a time frame in which to improve. Usually this will take the form of a performance improvement plan, i.e. a PIP. Very often employers will try and squeeze a PIP into a couple of weeks. However, a court will question whether the length of time is sufficient for the individual to make progress or be appropriately monitored. The time frame can depend on the role and the employee's shortcomings. So for example, if an individual is failing to check an entry on a form, the training and monitoring can be easily managed over a short time frame, whereas a senior sales employee with quarterly sales targets may need a full calendar quarter before any improvement can be monitored. Last, we have economic terminations, which usually require evidence of a fair selection process and also consultation. The aim of the selection process is to ensure that where there are a number of employees performing in the same or similar roles, equitable criteria have been used to determine who's selected for termination. So factors such as experience and skills and qualifications could be taken into account. Once selected, the employees are merely at risk of termination. Only after the employer has undertaken the consultation process can the termination be confirmed. In most countries, the consultation process requires an open dialogue with the employee over the course of a few weeks. The aim of the dialogue is for the employer to explain why a reduction in headcount is required and explore with the employee possible avenues that can be used to save their role, such as cost-saving measures or a search of the organization for another role. If at the end of the consultation period no alternatives have been identified, then the termination can proceed. Just to stop, Anuja, can you go back to the previous slide?
Sure.
Yeah, thank you. Once you've followed the correct process, whether for misconduct, performance or redundancy, and have decided to terminate, then you need to provide notice of termination in accordance with the local statutory minimum requirements. I presume some of you at this point may be shouting, what he's not telling us is that even if you follow the right process and you have a good reason, the employee's lawyer in Europe will always manage to get a sizable payout. So what's the point? Well, there is an argument for that, but in countries such as France, you possibly are going to get an additional payout. But what I would say is if you do follow the correct process, the amount paid will be significantly less if you follow the process than had you not followed the process. Now, it's interesting to note that even in countries where just cause is required, not all employees are capable of benefiting from it. So, in certain countries, the right to a just cause termination is based upon service thresholds, such as in the UK, where you need 24-month service. In Italy, only after you've finished your probationary period can you claim a just cause termination has been unfair. Or, in Germany, you need to have 10 employees in your organization before any one of those employees has the right to claim an unfair termination based upon a lack of just cause. So it always pays to check that your employees satisfy the qualifying criteria. So if the just cause termination is the daddy of all terminations, what is the next step down our scale? So there's a select group of countries, notably Spain, where they interpret a just cause termination slightly differently. In these countries, unless the matter is gross misconduct, it can be difficult to prove just cause. Now, obviously, experience tells us that most employees are terminated not for gross misconduct or for performance issues. However, this does not prevent an employer from terminating the employee. What tends to happen is that a penalty payment is paid to the employee in addition to his or her notice period as acknowledgement that the termination is without cause. So, for example, in Spain, that penalty payment is 45 days salary. You pay that, and there can be little chance of a challenge from the employee. So back to our scale. So we've just done type 2. So what is that type 3 that sits just above employment at will? Well, to be honest, not many countries operate like this in Europe. One of them is Switzerland, where it's not a million miles away from employment at will. Essentially, so long as the termination is not against public policy, such as being discriminatory, and you've done the right thing with regards to the notice of termination, then essentially you should be plain sailing with regards to that termination, that there isn't any opportunity for that individual to actually claim an unfair dismissal. So, based upon what we've discussed, so what entries could we include in our checklist? So say if you're going into a new country, what have we learned to assess whether the new country in Europe you're going into is an easy or hard country from a termination point of view? So this checklist down the right-hand side, we probably ask ourselves, does your country require just cause to terminate? If so, what reasons justify just cause and what processes need to be followed? Are there qualifying criteria, such as duration of service or local headcount or salary thresholds for the individual to claim unfair dismissal? Is there a local system of penalty payments in lieu of just cause, a la Spain? And what are the local notice requirements? So now on to our second slide. So the second major difference that you'll find between the US and operating in Europe is PTO versus annual leave, sick leave, and any other leave that European countries grant employees. So whereas US PTO plans don't really distinguish between employee absences, so that your personal days, your vacation days, your sick days can be bundled into one, but very often there's no carryover of any untaken allowance. The common international position in Europe is slightly different. So in Europe, most countries subscribe to having separate and distinct legal entitlements for annual leave, sick leave, and various other leaves. So there's no bundling those together. So let's look at each of those in turn. So for annual leave, and these are days exclusively used for vacation, an employee will be entitled to a minimum set amount of days per annum, as dictated by local statute. The carryover rules in each country do vary. Now, most fall on the side of the employee. So it either provides them with an express right to carry their unused leave forward, or it might say, well, look, if the employee has had work commitments that have prevented them from taking their allowance, then we allow them to carry over. So for an employer to defend that, you'll have to prove that you've actively managed the leave allowances. So you've set them at the start of the year, or you've chased the employee through with regards to using the allocation before the end of the year. In some countries, notably Belgium and the Netherlands, there's also a requirement to pay employees an increased rate of salary. So you're probably used to individuals getting paid their normal salary for days of annual leave, but in the Netherlands and Belgium, you pay them a premium. So you pay them a vacation bonus on top of their normal salary as well. So that's something to bear in mind. Note that the vacation allowance can also be a moving target. So in many countries, the statutory minimum entitlement isn't fixed. It might increase with service. In others, it will depend upon the employee's age. And in some countries, other less obvious factors come into play. One example is Hungary, where, say, you had an employee with 3 children, they can gain an extra 7 days over a colleague who has no children. So there's some arbitrary rules out there, and what we'll do is at the end of this, obviously that checklist will help you identify those. So note also that whilst many countries will operate the statutory minimum allowance, and most employers will actually apply that, there's a lot of countries where that statutory minimum allowance for leave will be wholly insufficient, and you're going to have to use market rates as well. So Germany, Austria, a number of these countries have collective agreements. Although those collective agreements aren't mandatory to you, they do tend to set a benchmark, and that benchmark can be 10 days above the statutory minimum. So distinct and separate from annual leave is the availability of paid time off for sickness absence. Now, this isn't an allocated amount managed on a use or lose basis. Simply put, if an employee is incapable of coming into work because they're ill, then generally they receive pay during their absence. Now, it is subject to annual limits and salary caps. Those salary caps are probably a little bit less than the salaries that we're used to paying in the US. But that being said, some of the allowances that you get in Europe, they're quite extensive. So say in Germany, it's 6 weeks or 42 days paid sickness absence. In the Netherlands, it could be 2 years. So it pays to understand what the system is. But what I would say is, I know those sort of figures seem a bit daunting. The system is very rarely abused, so people generally just take their sick leave for genuine absence. So beyond annual leave and sick leave, what other entitlements have we got? Well, usually it's leave on the occurrence of a key event, such as maternity leave or paternity, some civic duties or bereavement. But there is a trend to offer employees time off to care for dependents now. So a lot of countries are offering that. Some of them offer it on a paid basis, and some, and many, such as the UK and France, etc., offer it on an unpaid basis. So if we apply all this learning, again, looking at this checklist that you would need to have if you're going into a new country in Europe, the type of things I'll be asking is, what is the statutory minimum leave entitlement? How does it accrue? Does the statutory minimum allowance increase, such as with service or age? Are there vacation bonuses? What are the carryover rules? Is the statutory minimum considered too low, so you're looking at market rates instead? For sick leave, how many days are permitted? What is the rate? Does it need a doctor's certificate? And what are the other types of leave, and are these paid or unpaid? So if we move to the next slide, we can look at the next major difference. So we're all aware, oops, it's gone one too far, there we go. So we're all aware of exempt employees in the US, and I think it's worth actually checking out the US position on exempt employees versus the working time laws that you're going to probably come across in Europe. So for many of you, the US concept of exempt and non-exempt employees can exclude large sections of your workforce for overtime payments. So whilst many countries outside of the US and in Europe, they also have exclusions, it is generally the case that far fewer employees can be considered exempt. In fact, in Europe, the norm is that only those of a very senior level, such as VPs and directors, are considered exempt employees, in addition to some narrower sections of your workforce, such as home workers or those that are very sort of mobile, peripatetic sales employees that you can't monitor. So like in most sections under review today, there are some deviations from the norm. And it pays to know what those deviations are. So in the UK, you can actually get your employee to waive their rights to working time. So there's no weekly maximum working time that applies to them, and therefore it follows that there's no overtime either. In France, you can actually have your professional level employees work to an annualized working regime, so you're not tracking it on a weekly or daily basis, and therefore there's no overtime again. Now in Austria, there's a local practice whereby right at the outset of employment, you can actually split the base salary that you've negotiated. So there's one section that will be actually allocated to forecasted overtime, and the other is simply for basic salary purposes only. It's a bit of a trick because obviously you've negotiated that amount to be the basic salary only, but in the eyes of the court, that's a permitted way of actually paying for overtime during the course of the year. So you're not actually paying anything extra. However, in the main, and throughout Europe, you should prepare yourself for the position that overtime is something that you'll have to pay and you'll have to administer. And for a remote workforce, where possibly you haven't got local HR resource, it obviously raises some concerns with regards to how you're going to monitor that. Based upon the fact that overtime is obviously paid a premium in a lot of countries as well. So that can be as little as 25% in addition to your base salary, but in some countries it can be as much as 100%. And it needs to be pointed out that even if you're paying these guys this additional amount, you're still subject to caps on how much working time they can do. So very often you're only permitted 2 hours of overtime in a day, or possibly 6 to 10 hours in a week. So you've got to be mindful, even if you're paying the individuals, you are subject to caps. So again, that checklist, that's going to prove invaluable when you go into a new country. I would have the following down in your checklist. I would want to know what the standard working day or week is. I'd want to know whether there's an entitlement to paid overtime. And I would want to know what the rate is. And I would want to know if there's any exempt employees similar to what you've got in the US and what type of position they need to operate in. You need to know what the maximum limits are. As I mentioned, you can pay overtime. The individual can do overtime, but it's still subject to a maximum limit. And if there any local practice, such as in Austria, where you can split that basic salary. So moving on, and I'm conscious of time because obviously there's a lot to get through. So the next slide is our next key difference. So this is not quite as obvious as the other differences that we've touched upon, but I think it's different enough to actually justify its inclusion in this presentation. So with regards to employee inventions, it's generally accepted in the US that your employee can legally transfer their rights to any future invention which is either connected to their employment or connected to your business. Now, to do this, I think you're all probably aware of these pre-invention assignment agreements that a lot of employees will sign right at the outset of their employment, and they basically sign away their rights to those future inventions. Now, the European position on this generally follows the principle that the transfer has to occur at the time the invention is created. Now, there's reasons for that. Usually because there's a notification system that needs to be followed. There's almost a cooling off period where the employer's got an opportunity to mull over what that invention is and either claim it or not. And it's this type of thing that prevents you from actually having this upfront pre-invention assignment agreement. So you can't actually do that in a lot of European countries. Now, in most cases as well, that employee will also have the right to additional compensation, so their salary might not be enough. So where they've produced an invention, you may find that you're going to have to pay the market rate for that invention. So one way around this is if you actually detail in the job description, in the contract of employment, that one of the key duties of that individual is actually to create inventions, then it may be that you don't have to pay that additional compensation. So that's worth keeping in mind. In most countries, you also need to be aware that that non-compete that you have and offer to your US employees, where obviously there's considerations with regards to its geographical remit and how long it is in duration to make sure that it's reasonable. That might not be enough in Europe. So your non-competes in Europe, where you've terminated an employee, yes, you do have to make sure that it's got a geographical reasonableness and its duration is not too long. But in addition to that, there's well, most countries actually apply this system whereby you've got to pay the individual an amount during the course of that non-compete. So if your restriction is, say, 6 months or 12 months after termination, in many countries you have to pay the individual an allowance during the term of that non-compete. Now, in the Czech Republic, this is 100% of the basic salary. So effectively, if the individual operates a 12-month non-compete, then essentially you're paying that individual for an additional year after they've terminated. I mean, one further aspect of non-competes that's worth pointing out is that usually need to be part of that initial employment contract. So if they're not part of the initial employment contract, they're very difficult to introduce at a later stage. Now, obviously, at the stage when you employ the individual, you don't know whether they pose a threat to your business or not. And therefore, even a harmless employee who's been terminated for poor performance could receive non-compete compensation after they have left you. So when faced with this situation, many employers seek to withdraw the clause prior to termination. However, you need to be aware that that withdrawal of the clause often requires notice. Now, in Germany, the notice period to withdraw your non-compete is 12 months. So you've got this curious position that the result in Germany is that 12-month non-compete would have to be withdrawn 12 months prior to termination in order to avoid paying the employee 50% of the salary during the term of the non-compete. So often when faced with these complications, you might be looking at non-solicitation clauses instead, or a really tightly worded non-disclosure agreement rather than a non-compete. So for our checklist again, I would add, do pre-invention assignment agreements work? If not, what are the local rules regarding an employer raising a claim over an employee invention? And if we want to apply the non-compete, do they need to be detailed in the employment contract from the outset? Do they require payment? And can you unilaterally withdraw the non-compete? So moving on, and finally, I think this is the last key difference we're going to be covering, and it's collective agreements. So simply put, collective agreements are incredibly problematic. So it always pays to check whether they'll apply or not. Now, the collective agreement generally supplements the local labour laws. So it either inflates the minimum standards, such as better rates of annual leave. It can create additional policies, such as better consultation on termination. But in the main, it creates a hierarchy for you as an employer. So it will create grades of employees, minimum salaries, minimum benefits, and it's up to you to allocate the correct grade to that individual when they start employment. Now, the biggest difficulty with collective agreements is they're very expansive, they're written in the local language, and they get updated all the time. So to manage them remotely is almost impossible. So we need to know which countries have mandatory collective agreements. So in many countries, collective agreements are only applicable if the employer voluntarily signs up. So therefore, most international employers choose not to sign up, and therefore they're not an issue. However, in some countries, a collective agreement is deemed to apply indiscriminately to all employers in a particular industry. So countries with mandatory agreements are countries such as France, Italy, Spain, and Denmark. So you need to be aware of those mandatory countries, but you also need to be aware that in other countries such as Sweden, where collective agreements aren't mandatory, they can still influence your employment. So say if your employment contract was silent on the amount of annual leave you're offering an employee, the courts will often go to the collective agreement that's representative for your sector of industry. Might not be mandatory, but it's representative, and they'll select whatever's in that collective agreement as the leave allowance for the individual rather than the statutory minimum. So make sure that your employment contract stipulates statutory minimum in many countries, because otherwise you're open to the courts to actually apply collective agreements. So again, that checklist, when you're going into a new country, you need to check whether there are mandatory collective agreements. Is it based upon an industry or vocational? Is it regional specific? And what are its requirements? So I think with regards to what we've covered today, we've covered off obviously a lot of the key differences, and we've obviously generated this checklist. The idea is this checklist will help you when you go into a new country in Europe. But I want to leave you with some food for thought. So my final slide, if we just tab down, here we go. Oops. Yeah, avoid or embrace. So as mentioned at the start of the presentation, the aim of today is to generate a degree of familiarity with the common practices in Europe. So it gives you some foresight to ask the right questions to determine what the local requirements are. So rather than simply avoiding a country. So based upon my experience, other than for countries where there are mandatory collective agreements, local employment laws are generally not something you need to steer clear of. For example, there's a lot of our clients who try and avoid some countries in Western Europe because they fear the local termination laws. And instead they seek employment in countries with less developed employment laws. However, when they pick those less developed countries, they often encounter skills shortages or talent wars. So the question that needs to be asked is whether terminating a skilled European employee, say in Netherlands or France, after 3 successful years, and admittedly you'll have the associated processes and payouts, is it actually less costly than operating in countries where the termination laws are lax, but the role has been vacant for sustained periods, or the role holders have been less skilled during that 3-year period? Now personally, I would always prioritise access to talent above employment law considerations. Another point is I often see clients, instead of embracing the local employment laws, they're desperate to get into a particular country, so they'll use contractors instead. Now, the difficulty with that is it can be a higher risk strategy. So in dressing up the relationship as a contractor rather than an employee, you can be running headlong into agency regulations. And they have their own rules on termination as well. So very often a goodwill payment is due to a contractor on termination. And to be honest, that can be more than what is due to an employee on termination. So you've got to be careful. Now in addition to that, where you've got that contractor relationship, you could be risking your organization's corporate tax structure as well. So in many countries, there's an obligation on your contractor to disclose the details of any contracts that they have providing services to a foreign company. Now, you would be a foreign company in those circumstances. You wouldn't be employing anyone locally. The contractor would be doing your work for you. So in those circumstances, the tax authorities get to know what your local business is and whether you're tax compliant. So you're on their radar. Now, you wouldn't have that issue if you had just employed them direct, because the tax authorities wouldn't be interested in the corporate tax side. They would have no reason to make inquiry. So I think that concludes my presentation for today, and I hope it's given you not only that food for thought, but also it's given you a bit of confidence to actually move into a new country, ask the right questions, build up an idea of what is required in that local country, and not avoid it. And as I say, try and embrace what is the local requirement rather than just not go into that country at all. So many thanks for your time today, and I'll pass over to Carson.
Thank you, Stuart. That was very informative. I would now like to introduce our second panelist for today, Carson Kaling, Managing Partner, Pro Insurance. Carson began his career with Pro Insurance in 2001, transitioning from the cloud-based technology industry to employee benefits consulting, created a natural synergy between he and many of our technology-focused clients. Carson thrives on getting outside of the box and creating new and innovative employee benefit strategies to help clients differentiate themselves from their peers in an effort to attract and retain top talent. Carson's responsibilities span strategic consulting with current and prospective clients, leading the employee benefits consulting team and strategic planning of the firm. Over to you, Carson.
Great. Thank you, Anuja. Are you going to give me mouse access on this side?
I have.
There we go. Okay. Okay. Great. Thank you very much. So today we're going to discuss the employee benefits landscape in Europe. And as Stuart referenced before in regards to employment law, the same really applies to benefits. There's so much we can go over with every country in regards to employee benefits in Europe. There's no way we could cover it in 1 hour. It would probably take days. So this is just designed to give you some foresight, some background knowledge, and give you the right questions to ask to avoid pitfalls when you do go into different European countries in the future. So we're first going to go over the statutory benefits because they do vary greatly between European countries, and especially when you compare them to the U.S. So it's extremely important that you know these statutory guidelines, you do comply with them, because if you don't, there could be huge economic penalties for you. Knowing the local benefits landscape, of course you want to be competitive. You know, we're trying to attract and retain top talent, but we also want to be cost effective. So how do we do that and walk that fine line? Implementing a group benefits program. There's a certain timing and process to do that. We'll also go over that. And then implement effective employee communication strategies. And this starts really from the very beginning, from when the employee is actually a candidate and not yet an employee, making sure they're aware of what's going to be offered to them and what benefits they will have when they become an employee. And then once they are an employee, when do they sign up for benefits? How are those benefits administered? What exactly do those benefits entail? And where do they go if they have a problem? Those are commonly overlooked items. And then one common theme that we're going to see throughout this presentation is maintain centralized HR control over benefit programs. Probably the most common mistake I've seen is when HR control is given to the first employee, say, hired in the UK, for example. In many cases, that's a salesperson. You know, the company wants to generate revenue first before anything else. So they'll hire a salesperson, and that salesperson is given control over what benefit plans to implement, and really they're talking about for themselves. But what that does is it sets a stage and sets a precedent going forward. So it's very, very important that you maintain centralized HR control, whatever country that may be in. Maybe it's the U.S., maybe it's somewhere else, but maintain that centralized control over your global benefits program. So now we'll go over some examples of contractual and statutory requirements in different countries. I wanted to outline a few examples here that are some of the most common that do come up. So as Stuart mentioned in his presentation, France is one of the countries that does require collective bargaining agreements. So as a part of that, there are certain employee benefits that are mandated. So if you are going to have employees in France, you are mandated to offer death and disability coverage for all employees. And the law really goes further than that. It not only mandates it, but it says if you don't put those coverages in within a certain period of time, then they mandate the insurance carrier and the insurance product that you must use, which, as you can probably guess, is a very, very uncompetitive and highly priced product. So it's extremely important you know of these requirements when you're going into France, and you have a plan to put those different benefits in place when you first have employees in the country. Germany is another country that has some unique statutory rules, and one of them is they have works councils where employees can essentially represent themselves or have a council to represent the employees for employee benefit practices. Many countries have different sizes when works councils start applying, but once they do apply, it's similar to a union. It's not necessarily a collective agreement, but similar to a union. So in order to change any of the employee benefit programs, you must first go confer with the works councils, and it must be agreed upon. Now, the UK, an example in the UK is pension plans. So there are statutory requirements regarding pension. It formally was that if you had 5 employees in the UK, you must offer a pension program. Not necessarily contribute to the program, but you must at least offer a program for employees to utilize for preferential tax treatment. That went out the window in October of 2012. In October of 2012, there was a significant pension change in the UK. So no longer is the employer required to offer the pension plan in general at 5 employees, but now every single employer in the UK has what's called a staging date. And as of the staging date, which is at a point in the future, and dependent on their size, industry, and a few other items, upon their staging date, they must not only offer a pension plan, but they have to auto-enroll employees in the pension plan. And then at a certain point in time, they must start making contributions to the pension plan. And then those contributions do increase over time until they get to an employer contribution of 3% at a future date. So there's significant changes there in statutory law that have serious economic impact. And employers should definitely know about that and be familiar with that before going to the UK. Netherlands is another great example. So in Netherlands, many employers don't know that if an employee they have in the Netherlands is disabled and unable to work, they have a 2-year obligation to pay that employee. So 100% of the compensation will be due for year 1 of disability, and then 70% of compensation in year 2. That's a huge amount, especially for a company that may have 1, 2, 3 employees on payroll in the Netherlands. So that could be 30% of your payroll going to an employee that's not even at work anymore. So there are certain ways to get around that, or at least ensure that risk. If you don't have short-term disability coverage in the Netherlands, essentially you're self-insuring that risk. So knowing these things before you enter the country, again, is very, very important. And then when you are putting insurance contracts in place, or any sort of benefit contract, pension or otherwise, make sure you know what you're getting into. Many times there are annual contracts that are in place. Here in the U.S., usually it's a monthly contract. For a medical insurance contract, for example, any given month you don't pay the premium, you can automatically get out of the contract. In many countries, it doesn't work that way. It's an annual contract. Maybe you pay the premiums annually. And if you went out of the contract, that's fine, but there's no return of premium. So know what penalties and stipulations apply if you do need to terminate a contract mid-year. And then also notice to employees. In many countries, there is a contractual notice to employees that's required before terminating benefit plans. So even though the insurance carrier may allow you to do that, by law, you can't do it without proper notice to employees. So now we'll go into knowing the local benefits environment for a couple reasons. One, again, we want to attract and retain that top talent. That requires a competitive benefits program. If you don't have a competitive benefits program, sometimes you can make that up in cash compensation or equity. That can be a way to sometimes attract talent. But in general terms, over the long term, you will need to have some sort of comprehensive benefits program in place. So that requires knowing the local benefits landscape, knowing what the statutory requirements are, also knowing what the norms are. You know, even though supplemental medical may not be required in the UK, is it something that is the norm, and without it, will I be able to attract and retain employees? The other reason we really need to know the local benefits environment is because employee benefit contracts can be abused and requests can be made that are unreasonable. For example, if you're hiring an employee in another country and life insurance comes up, and maybe you don't have a life insurance plan in place yet, so they're going to request a stipend or that you reimburse them for a life insurance or medical policy. A term life policy is a very inexpensive way to go, and is the norm when it comes to life insurance for a group to offer a group term life policy. A whole life policy, it accrues a cash value, essentially as a savings vehicle. The cost of this is about 10 times the amount of a term life policy. We've seen many situations where candidates come in and essentially give the recruiter a quote for a whole life policy saying, I'd like life insurance, here's the proposal for my country. The recruiter has no idea that it's a whole life versus a term life policy, and essentially by paying the premium, you're paying that employee additional compensation. It's accruing a cash value in that whole life policy. So it's just very important to know the details of benefits in any country going into before signing employment contracts with employees or offering them benefits. And many times the first person, again, can be a salesperson. So setting the precedent is very, very important, and keeping that HR control in a centralized location is very important. If you let the employee make their own benefit choices, 9 times out of 10, they're going to choose the richest and most expensive benefits plan. So there's a conflict of interest there, doing what's right for the company versus doing what's right for the employee. So having a centralized HR presence in place does help with that. And then depending on company philosophy, you want to determine some sort of equitable approach across the globe. So if you're trying to put in benefits in Europe, do you want those to be somewhat similar in philosophy to what you have in the US or maybe in Asia, for example? If you're deciding that you want a very rich benefits program covering 100% of employees' independence for the medical program, is that an equitable approach you're going to roll out amongst all countries? We find that if you do have an equitable approach like that, it does help long-term with your global workforce and culture. And just make sure you have a trusted partner in the local region, someone that can tell you the norms, someone you do trust, and someone that can lead you through all the compliance issues you may have if you don't comply with the statutory requirements in each country. Anuja, oh, there it goes. Okay. Implementing a group policy when able. So again, going back to many countries or companies, when entering a country, they may only have 1 or 2 employees when they first start up a benefits program in that country. So whenever you're able to, definitely implement a group insurance policy. It'll do a few things for you. It'll leverage economies of scale. When you start a group policy instead of individual policies, in most cases there are significant cost discounts. So there will be a lower cost. Multinational pooling is sometimes a situation that can help here. Multinational pooling allows you to essentially pool certain types of benefit plans, for example, life and disability insurance, among countries. So if you have plans in the UK, possibly Canada, and Ireland, you may be able to pool the risk of all of those plans under a multinational pooling agreement. That will give you lower costs, higher guaranteed issue amounts. So for life insurance, if you're offering 4 times salary, which is very common in the UK, however, only 100,000 of that is guaranteed issue, meaning not subject to providing health evidence of insurability. Yet under a multinational pooling agreement, that may be as high as 500,000, which completely gets rid of the need for your employees to go through physicals and examinations before they're approved for insurance. So it can be very convenient and can be a great benefit. And then the multinational pooling agreements also offer dividends. If you have very good claims experience, at the end of the year, you can actually get a dividend check from the multinational pool. So it can be helpful in that regard as well. And there's also stronger coverage available than with individual plans. Individual plans is insuring one person or one family. It's a very small risk pool. The larger the risk pool, the better the benefits, the more comfortable the insurance carrier is. And then, of course, ease of administration. With the group policy, it's consolidated billing, and it's a consistent practice for all employees and candidates. Now, when can you put a group insurance plan in place? Many times you can with as few as 2 employees. Sometimes it takes as many as 5 to 10, and there are certain countries where it takes more than that. But once you have 2 employees, I would recommend start researching group benefit options. Therefore, any future hires you have a consistent benefits platform to join. Benefit communications. Make sure you have effective employee benefit communications tools available to you. When do the benefits begin? That's something the candidates will often ask when they're being interviewed for the job. When do I receive employee benefits? When is my family going to be insured? Make sure you have a very, very clear communication point for that. Many countries have pre-existing condition clauses. For example, in the UK, if you have fewer than 50 employees, most insurers will say, we don't cover pre-existing conditions. We need to make sure all candidates and employees are aware of that, so that if they do have pre-existing conditions, we can help them navigate that and find other means of covering those. What are the guaranteed issue maximums? Again, pooling is helpful here, but if we're offering 4 times salary, but there's only 100,000 guaranteed issue, we need to make sure the employee knows this is subject to providing satisfactory evidence of insurability, so they're not misled. And who is eligible to join the plan? This differs from country to country, but in most cases, of course, spouse and children are able to join, but in some countries, parents and grandparents are also able to join the benefit plans. And then for any issues that do come up, who is a local resource for employees? So you do need some local resource that knows the lay of the land, knows the medical culture of that country, and knows how to solve problems. So whether that's HR, whether that's a local broker or insurance representative, make sure they're aware of that resource. And then recruiters should be very clear of understanding all benefits. So when they are talking to candidates, they can be very clear and defined as to what the benefits are in that country and put that in the offer letter. And then this last slide, I know I've mentioned this many times, but it's very, very important. Maintain centralized HR control over your benefits programs. I've seen it many, many times where a controlling force in the local country that's not related to HR at all. In many situations, it's sales tries to take control of the program to increase benefits for themselves and the other employees in that country. And it may be outside of the philosophy or outside of the budget of the general company. So make sure you maintain consistent HR control over that. And then compliance. You know, I know all of us will be shocked to hear this, but salespeople are not necessarily the best compliance advocates. So make sure that you have a centralized HR control over compliance as well, and making sure that all the benefit programs you offer are in compliance with statutory requirements of that country. And then again, try to maintain a consistent global benefits culture. You know, by doing that, you can have very, very good communication tools that go out to all countries, and everyone feels like it's a very equitable approach across the globe. We find that's a very, very effective means of managing a global benefits program. So again, this presentation wasn't meant to go into each specific country and go over every single statutory requirement or benefits norm in each country, but it was designed to give you a good feeling for what questions you should be asking when going into new countries, and some resources to help answer those questions. Over to you, Anuja.
Thank you, Carsten. I'm sure our audience have benefited greatly from this input. I can see a lot of questions have come in. We will go through as many as we can. Stuart, the first one's yours. What's the biggest mistake U.S. employers make when venturing abroad?
Yeah, good question. So, I mean, in general, what we tend to see is it's a failure to learn from experience. So, I mean, if you liken it to sort of be on a roller coaster, you think it's going to be scary, so you cover your eyes with your hands until it's finished. So, the difficulty with that is you don't experience the ride. So, when you do it again, you put your hands over your eyes and you don't experience that ride again. And it's a bit like this with some of our clients. So, the fear of new countries, it prevents them from experiencing that ride and learning as they go along. And they take this blinkered approach every time, and they keep coming back to us with the same question. So from my point of view, I think the biggest mistake that US employers make is they don't learn from that first country they go into. There's going to be teething problems, but if you learn from that experience and you take it on board, then the next time you go into a new country, it's going to be a whole lot easier. And hopefully my presentation, it did sort of highlight there's some common trends between countries, and that learning experience will count you in good stead for the next country.
Thank you, Stuart. Carsten, I have a question for you from the audience. If we do not have a pension plan set up in the UK already, how do we know?
staging date. But it's not necessarily dependent on just your size. There are other factors as well. So what it ends up defined, the definition of your staging date is defined by your PAYE number. So every company has a PAYE number that's used for payroll. You can actually go to a website that's with the HRMC in the UK and find out by putting in your PAYE number what your exact staging date is. You want to make sure, but once you define your staging date, by the time that comes along, you've implemented a pension plan, you have auto-enrollment for all employees in place, and that doesn't mean that they have to participate in the plan. It means they're auto-enrolled, and they have to opt out if they want out. But initially, they must be enrolled by the employer. And then if you are required to make a pension contribution, that you are making that pension contribution by the required deadline. So I would say define your PAYE number, and then go to the website and find out exactly what your staging date is.
Thank you, Carson. Stuart, I have one more question for you. You mentioned collective agreements are mandatory in certain countries. In those countries, how do you know which one applies? I get the impression there may be hundreds of different ones. Could you clarify, please?
Yeah, this is where it gets rather complex and obviously beyond the scope of potentially today's presentation, but it is a good question. And it's very much based upon an appreciation of what is local. So in France, for example, where you're setting up a company or a representative office, as part of that registration, what you're going to do is you put down a description of your business activities. Now from there, the authorities, when they register that entity, they will actually issue you with a code, and it's called an APE code, and that designates the collective agreement that applies to you. Now in France, there's literally thousands of collective agreements, so depending upon your description, slight nuances in that description can actually result in a different collective agreement applying to you. So you've got to be very careful as to what you describe your activities as when you set up your company. So that's France. I mean, another country in Europe where collective agreements are obviously very prevalent is Italy, but they take a slightly different approach whereby there's not thousands of collective agreements, there's a handful. And what you find is that they've split those collective agreements into a collective agreement that covers manufacturing or a collective agreement that covers service or tertiary industries. So it's not really specific to a particular industry, it's more with regards to whether you manufacture, whether you do services, etc. So it's easier in Italy. You basically, you're pretty clear on what collective agreement is going to apply to you from the outset, and it doesn't take the authorities to actually assess what that is for you. Another country in Europe where you've got collective agreements is Spain, and you know, Spain is very local in the way that they do it. So France is very specific on industry, so you've got thousands. Depending upon what particular industry you're in, you get a different collective agreement. But in Spain, there are specific collective agreements per industry, but what you'll find is then it's sort of cascaded down, and you've got different variations on those collective agreements depending upon your geographical location. So you might be in engineering, and an engineering collective agreement for a company based in Seville is going to be very different to a one based in, say, Madrid. So you really need legal input in Spain, either that or speak to an employers association in your particular sector to determine just how local those agreements are. And you'll be surprised because they are very local. So you can have a different agreement 20 miles down the road compared to what you've got in one factory compared to another. So yeah, so there's a lot to consider. My advice is collective agreements are incredibly difficult, and you really need sort of local support right from the outset in countries where you know that there is an agreement applying. So France, Spain, Italy, Denmark, keep in mind those sort of countries and be prepared.
Thank you, Stuart. Carson, it seems we have one more question for you. This is very interesting. What does an employer do if they have 1 or 2 employees in a European country and are not able to implement a group benefits program? How do they provide for the 1 or 2 employees?
Yes, Thank you, Nusha. That's a very common question that comes up. As companies go into different countries, they often have 1 or 2 employees that are just starting up the office in that country. So if a group plan cannot be implemented, a few ways you can go. If the company has an expatriate policy in place, which most companies do, to cover the few employees they have that are working outside of the U.S. on assignment, anywhere in the world, most of the stronger expat plans will allow local nationals to be on the plan as well, up to a certain ratio. So they may say, for example, you can have up to 30% of the people that are on the expat plan be local nationals. So I would say, number one, look at that. Can we put them on the expat plan? Because if they're on the expatriate plan, usually that's very good coverage for medical, many times dental, vision, life, disability, and it's very consistent, easy to administer. You pay one bill and it covers all of your expats, including the local national that you just put on. So I would say that would be number one. The cost of doing that sometimes is somewhat high, but until you have a better solution with a group policy, I would say that's probably your best solution. Number two would be some sort of a stipend. So many times we see this. We see an employer in an employment contract will give a certain stipend for benefits. You're able to submit receipts for medical premiums, life insurance premiums, possibly disability, up to X amount. Maybe it's up to €500, whatever the amount's going to be, on a monthly basis or on a quarterly basis, however you want to do that. So I would say a stipend as well. But just be careful never to guarantee coverage. Even if you're expecting you're going to be put in a group plan and you will be offering medical, life, disability, etc., never guarantee it until you have those plans in place, because you may find it's very challenging to get the plans in place in certain countries, and you don't want to be stuck in a situation where you've guaranteed this employee coverage, they can't get it on their own because they may have a health condition, yet it's guaranteed in their contract. So always have some sort of caveat in there saying subject to evidence of insurability or subject to the company's ability to provide this coverage.
Thank you, Carson. I think we have just enough time to squeeze in one more question. Stuart, that's for you. There must be things that your checklist won't highlight. Could you discuss that, please?
Yeah, it does highlight a flaw in the checklist. So it's obviously not going to cover everything. It's designed to cover sort of the headline issues, which potentially are going to cost you the most. So terminations and annual leave, etc. But there are nuances in each country that obviously no checklist in the world will actually uncover. The idea is that they're the type of issues that aren't really going to hurt you. They're more to do with sort of cultural norms that you'll only really get to know once you immerse yourself in that sort of local country. I mean, for one example, we've had a recent client who operated in Denmark. Now in Denmark, most households are sort of dual income, so both parents are working, and there's a local practice whereby one of those parents will come out of work, do the school run, and there'll be sort of down tools for that hour when they're doing that. But local practice also dictates that they will come back to their work after that, often working in the early evening. So it's those sort of quirks that you're never going to get a checklist to actually cover off. But that's what's fun about doing international business. That they're things that add a bit of spice, but they're not going to be costly.
Thank you, Stuart. We don't have any more time to take more questions, but I can assure you we will send them to the panelists and we will try and answer as many questions that have come in directly to you. I would also like you to go to the Nair & Co website and Pro Insurance website if you need further information. Everything's been posted on the website and the recording will be available soon. I thank you all for attending today's webinar.